Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, no persons having business with the Appellate Division draw near. Give your attendance, and ye shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division First Department. Most of you are familiar with our practice. I will go through the call of the calendar. Please request only that time which you actually need, not what you want. Understanding that the clock is for you, not for the court. So I do not interfere with my colleagues if they have questions beyond the light, okay? So if you argue well, you get more time, okay? All right, that being said, People versus Jake Hall. Great start, submitted. Jewish Press versus New York City Department of Records.
Joseph Barron for petitioner, 8 minutes and 5 for reply.
Okay.
Jeremy Pepper for the city, 7 minutes.
5 and 1 and 5. Atia versus Slazer Enterprises.
Appellants requesting 6 minutes and 2 on reply.
Okay. So are you, the appellant, are you arguing for all appellants?
Yes.
Okay, all right, so then 6 and 2, and how much time did you request? 2. Oh, I'm impressed, 2. Okay, 2. People versus Terrence Graham. Okay. 6 and 2 and 6. Reed versus 645 LLC. Okay, submit, thank you. People versus Sammy Lopez. Submit. Singer versus Bill de Blasio, et al. Okay. Are all the appellants here? Okay. Got it, all right. Okay. And? How much time? Are you each asking for 3 and 1? Okay, we've got to keep the appellants to 15.
Yes, sir. 3 and 1.
Okay.
And for George Hart, 2 and 1.
Okay.
Mr. Wall, 2 and 1.
Okay. Respondent?
Request 7 minutes.
Okay. All of the time requested is granted. Okay? All right. Gilder versus Stern.
Good afternoon, Your Honor. Appellant request 8 and 2.
Okay.
Respondent 7 and hopefully not anything that long.
Okay. Let's do 6 and 1 and 6. Salitsky versus Atanastasio. And I know I mangled that name, and forgive me. Sure, 2 minutes. People versus Rosita Sanders is submitted. Northern Star versus Micro Office is submitted. Bankers Conseco versus Wilmington Trust is submitted. Brown versus Neighborhood Association is submitted. First case on the calendar, Jewish Press versus New York City Department of Records. Please come up. You may proceed.
Good afternoon, Your Honors. So this is a FOIL case, and I think it really boils down to 2 issues. One issue is, were any of the records requested by the Jewish Press publicly available? And the second is, of all the records that were ultimately produced by the respondent after commencement of the proceeding, did those records constitute the creation of a record, or was it just generating a report from a database in accordance with 89.3? So I'll address the publicly available first. So I think there's no ambiguity in the record that all the records requested by Jewish Press were not publicly available. And again, they requested FOIL logs in a directory of FOIL officers. In terms of the FOIL logs, Jewish Press made the request.
Wait, you say that they were not publicly available. How were they not publicly available on Doris?
So what Doris does is, if I could point Your Honor to page 127 in the record, you could see how many requests were made to any agency, and there's 5 columns that are publicly available. Those columns don't include a description of the request. They don't include the name of the organization that made the request, and they don't include why the request was closed. In other words, was it denied because of privacy? Was it denied because there was an ongoing investigation? None of that is publicly available. So again, the record citation of the what is publicly available is on 127, and it's 5 columns of information. What was ultimately given to petitioner, you could see on the record on 119.
Counsel, would you kindly slow down a little bit?
I'm sorry, I apologize.
I'm sorry, let me just go back 1 second. Wasn't the list of FOIL officers produced before the action was commenced?
For approximately half the agencies, Doris runs FOIL on open records for, I think it's 58 city agencies. So half of those were produced prior to the commencement of the proceeding, and the remainder were produced, I think it was the day before they made their cross motion to dismiss on mootness grounds. But in terms of the other side of the request, the FOIL logs, there was not a single log produced until the commencement of the underlying Article 78 proceeding. Now, I just want to address again with the publicly. On Doris's website, which the court could take...
Wasn't the primary issue regarding those documents whether or not they had to be created by the agency as opposed to previously existing?
Yes, Your Honor, absolutely.
Isn't that what you should be focused on, whether or not they actually had to create that in response to this, or whether it was something that was available before?
Yes, and that's a great point, because it sort of brings about the contradiction in respondent's argument, which is A, they were publicly available, and B, we had to create them. Those things in of itself is an inherent contradiction.
Not necessarily. Just because they appear on the site overall doesn't mean they appear in the manner in which they were requested, which is precisely what they said.
I agree with that, Your Honor, and our response is, in 2008, there was an amendment to the FOIL statute that codified a Court of Appeals case called Data Tree, and it said, recognizing that records today are kept in a database in digital form, asking a agency to query the database and generate a report, the words in the statute is that that does not constitute creation of a record.
But that is only the case if indeed it is as simple as you just described,
So
right?
it's not-
So let me
Sorry.
finish, because I'm still talking.
I'm sorry, Your Honor.
Okay, so if you are able to ask the computer, ask the system, give me X, Y, and Z, and it has the capacity to do that without any interference by any IT specialist, is one thing. It's another thing if you have to really go into the system and then, which is what happened here, they literally had to shut their system down. And this wasn't, as you suggest in your papers, just a few clicks and the computer generated that's not what happened here.
It is, Your Honor. May I respond?
That's not what happened here. And tell me where in the record
Absolutely.
you prove that what they suggest, that they had to shut the system down, it took a multitude of IT specialists in order to run the query, and it took 2 to 3 days to compile.
Okay. So that's a good question, Your Honor. We agree in terms of the law.
I'm so glad you agree. Go ahead.
In terms of the facts, we couldn't disagree more. What Your Honor stated was stated by counsel at oral argument. The record, the sworn testimony states the exact opposite, and I'll point the court's attention to the record at 119 and 138. In the entire case, I acknowledge what your judge is saying, comes down to those 2 record citations. The record citations say that on their database, there was a data export button that they pressed, and therefore they were just able to download all the records to an Excel spreadsheet. And that's their sworn affidavit. The notion that they were shut down for 3 days was literally just pulled out of thin air, and it was said for the first time at oral argument. It doesn't exist anywhere in any of the affirmations, in any of the affidavits. The only place that exists is in the transcript of oral argument in front of the trial court, and in the trial court judge's decision. Nowhere in the record does that exist. In the affidavit put in by Doris, it says the exact opposite. That's at 119. And Doris wrote a letter to the trial court. That's the record at 138. And the letter also says that the data was retrieved by utilizing an Excel export feature. That's a direct quote from the affidavit of Doris. So the notion that there was any undue burden whatsoever is totally unsupported by the record.
Okay, my colleague has a question.
I have to say that I wonder whether your basic challenge to the materials that were provided to you have more to do with an objection to how the software is set up. In other words, the category, the way the categories are set up, the way data is retrieved, the way it spits it out subsequently. Your request was very specific. You wanted a FOIL log of all requests made through the Open Records portal within the last 12 months in Excel format. So you had your own parameters as far as the result that you wanted. So I don't know, given what the statute says with respect to production, in other words, that materials that are either within the owned, possessed by the system have to be turned over upon request, or if the materials are not available, if within reasonable efforts they can be made available. I don't know that your challenge makes sense under these circumstances.
So yes, let me address that, Your Honor. So we were actually given exactly what we asked for after the proceeding commenced, which was an Excel spreadsheet with 10 columns with all the data they collect, including the description of the FOIL request, the reason the FOIL request was closed, and the name of the entity making the request. This is all data that they upload regularly on open data.
My understanding is that this is the first time that this type of run was made, and that because it was the first time that this type of run was made in response to your query, the amount of tech support, the amount of work that was required to produce the report shut down IT to the point that it could not do any other work or respond to any other queries but for yours. So under these circumstances, I'm floored that you would say that you prevail, that you are the prevailing party. And maybe I'm jumping now into something that should be responded to on rebuttal.
So, Your Honor, if what you were saying was true, I agree. But again, there's nothing in this record that says that anywhere. The only place that comes up that they shut down their IT department for 3 days was an attorney's representation at oral argument. You could look at Ms. Velazquez's affirmation, which is her sworn testimony about what was involved. And again, the record site is page 119, and she said the system has an export feature to Excel. They export it to Excel.
The basic remedy, the basic relief that you seek is attorney's fees. In other words, you got what you wanted. It took longer than you wanted. You got it in the format that you requested, but the only part that's missing here is that you should receive attorney's fees because what? They didn't make reasonable efforts to provide you with the information?
That's correct, Your Honor. So what the statute was amended in 2017 says that attorney's fees are mandatory if the production was a result of an Article 78, which it indisputably was here. In terms of reasonable basis, how could they have a reasonable basis?
It's not just that it is the result of an Article 78. It's that you have to seek the relief under Article 78 where the original request was not reasonably
denied.
dealt with.
That's correct, Your Honor. So in this case, they didn't know the capabilities of their system. That's not a reasonable basis. In this entire record, there's not one document.
Says who?
Says Ms. Velazquez in her affirmation. Ms. Velazquez says sworn testimony.
No. I'm saying if So we're getting into tech, which is an area in which I'm really comfortable, okay? If a provider is unfamiliar with the broader applications of its software system, does that mean that reasonable efforts weren't made to produce information which ultimately results in your receiving attorney's fees?
It would depend, Your Honor, on whether or not they made an effort to ask an IT person if it had an export function prior to commencement of this action. There's nowhere in the record where it says they made any effort to contact IT. In fact, Ms. Velazquez says, and she spells it out line by line and paragraph her affirmation, when she was assigned the case, she went to speak to IT and she discovered that it could all be exported. And the second thing I want to note, there was two parts to the request. One was the FOIA log, and the second was the contact information for the record access officers.
You know how
All right, let's just say you have now doubled your argument time, okay? So you will have a minute on rebuttal.
Thank you, Your Honor.
You may proceed, sir.
Good afternoon, Your Honors. May it please the Court. Jeremy Pepper for the New York City Department of Records and Information Services. This Court should affirm the below order dismissing the petition. I just want to say at the outset, the appellant has failed to exhaust their administrative remedies.
Can you address your adversary's arguments that nowhere, other than at oral argument, was this argument raised about 3 days of time of an IT department having to shut down its system?
Sure, I would first say that the attorney below, an officer of the court, made a representation to the.
But why would that representation not be included in the affidavit submitted in support? I find that troubling.
I want to note what the affidavit in support says. It doesn't. I think at some point it was stated that it said that all it took was the push of a button. It said there was a data export feature. I'm not a computer expert. I have no idea what that means. I don't know that that's necessarily a quick process, and I don't think we should assume that it is.
Counsel, there's a difference between I can push a export button on the computer and get what they asked for originally, and I had to shut down my department for 3 days in order to accomplish this. So I'm trying to understand the vacuum between those two things.
That's a fair question.
I'm glad you think so.
I will concede that nowhere in the record, other than the statement made by the lawyer to the judge, does it say that. I would posit that it's somewhat immaterial. There's plenty of other reasons why attorney's fees should be dismissed here.
So explain to me why, if indeed all it took was the push of the proper buttons to export this information, why it had to take an Article 78 to accomplish it.
But there's nowhere in the record that said it just took a push of a button either. So that is a leap of faith as well. And so it said there was a data export feature that had to be accessed.
Well, who has the obligation of establishing the reasonable efforts taken on the first go-round?
The Department of Records, Your Honor. But I would posit that the information requested was publicly available.
That's where I want to ask some
Yeah, and so there was a decision that just came out yesterday.
That's what I want to ask you about.
Right.
So the your adversary was directed to the public portal, right?
Yes.
And my question here is, was this information available on the open portal, all of it? And two, was it available with a push of a button?
On the Open Records website. So your question has a couple parts. I want to break it up. Of course, his request had two parts. The first was, and I want to quote because it's important, he requested a FOIL log of all requests made through Open Records portal over the past 12 months. Using Open Records, it is possible to create log is a word. You can access information about all FOIL requests filed through Open Records for a year's time. He argued that there's information that was later turned over that wasn't included in that, but the information he referenced wasn't included in his FOIL request. Doris went above and beyond what they had to do in order to resolve this litigation, and he's using it as an excuse to get attorney's fees. The website, publicly available, would provide the information that, according to his request, he was looking for. If he wanted the information that wasn't available on open records, then that should have been included in a request, and Doris would have responded accordingly. As for the the FOIL officer directory, first, as Doris responded, there is no FOIL officer directory. There's a directory of FOIL liaisons, which are not necessarily the same thing. So just by the virtue of the fact that Doris does not maintain such a directory, that's a reasonable basis.
As I understood the record, the response was basically, those agencies that have an officer that is responsible for these FOIL requests, each agency has a list of who that is, but there is not a master list of
Right.
all the agency FOIL liaison officers.
Right.
Am I correct about that?
To my understanding, yes.
So that your adversary here would have been able to ascertain this information, but would have had to go through each agency's records in order to ascertain it, as opposed to getting a master list.
But if Doris doesn't maintain
This is a
it-
friendly question.
Okay, yes, that's correct. And
Okay.
Your Honor, if you will permit me just one more quick sentence, I just want to
Yes.
say, in my opinion, Doris is doing the right thing here. They're making an attempt to put stuff on the internet for the public to view. I mean, that is what we want from government agencies. And so, just for the policy point of view, I think that this is the right thing, and we should be supporting it.
Can I just ask one quick question?
Sure.
At the end of the day, the Excel document that was given to the petitioner was not a document that was press a button and get, correct?
To my understanding.
And
now-
I don't think, I just went again through the Velasquez, and she doesn't say it was press a button and correct. I don't know what,
No.
whatever petitioner, I just went through that affidavit again, and she doesn't say, sure, we could have pressed a button and got it.
It
There's
says-
a feature, there's an Excel
Right.
feature that had to go into and spend a lot of time figuring it out, and it wasn't a document. It was a document that Doris created.
Right, and
Correct?
throughout his brief, he mentions that Doris manipulated the data, and
It
that's
wasn't
creation.
a press a button. Doris created a document in response to the request.
That's correct. Thank you, Your Honor.
Thank
If there are no other
Thank you.
questions, I'll rest on my briefs. Thank you.
Thank you so much. Counsel, you have 1 minute, and I'm keeping you to your 1 minute, okay?
Quickly, thank you,
All
Your
right.
Honor. I just want to address two things. One is the second half of the FOIL request was for the RAOs. So we were not given a complete list until the action commenced, and then they gave a complete list. The list was theirs. They maintained
What's
it.
RAO?
I'm sorry, the FOIL officers. The second part of the request for the FOIL
All right.
officers, and they produced the list, which they had the whole time, and they didn't give it prior to commencement of this action.
How do you know they had it the whole time?
Because
I
on,
mean, you make these statements, they said they are not available in one comprehensive list. They can be gathered and put together, which is what they did and gave to you.
they said that they generated a report from their data.
Generated means it doesn't exist.
Your Honor, I agree. None of this
Okay.
existed, but FOIL, the statute in 89.3, and I attach both the Senate and the State Assembly's justification when the law was amended in 2008. If FOIL wasn't if databases weren't subject to FOIL, there'd be no more FOIL today. Records are held in databases. Anytime you make a FOIL request nowadays, what it requires is for somebody to query the database and run a report. And I have in the language from that memorandum of justification from 2008, the entire law in 89.3 was amended exactly for this purpose. It says in it that generating a record from a database does not constitute creation of a new document. So they would have the burden on
So
them.
long as it doesn't, you keep on,
correct, Your
leaving out the most important language in that decision, which is it depends on the extent to which additional efforts have to be made in order to generate the document.
That's not correct, Your Honor. It says undue burden is not an excuse. In the statute in 89.3, it says undue burden is not an excuse. And if it's
Counsel.
an undue burden,
No
we
more
should have the
questions.
opportunity to pay for an agent, for another third party to run it. That's all statutory. It says-
Thank you.
Thank you, Your Honor.
Atia versus Slazer Enterprises.
I think they're just submitting.
You may proceed.
Good afternoon, Your Honors. Matthew Lavoie of Newman Myers for appellants Bovis and Slazer. First, appellants sufficiently established that they lacked constructive notice of.
Well, counsel, let me just ask you a question about the constructive notice issue. I know that the witnesses testified what they would generally do, that they would inspect, they would walk around at the end of each day. Was there anything in the record that would establish that on this particular day, going into the next day when the injury happened, that there had been some sort of inspection? Was there anything specific other than these general representations?
Yes, Your Honor, I'm glad you asked that because it's not a general cleaning procedure as the lower court stated. The testimony from the superintendent, Mr. Hires, he specifically stated he was personally on site every day from 6 a.m. to 5:30 or 6 o'clock p.m., that he was specifically on site on the date of the accident, and more importantly, that he personally conducted an inspection of the site every morning when he arrived and every evening before he left. And
Right.
Again, go ahead.
But on that particular day, the date in question, did he testify that, yes, I had done that as I normally do, and additionally, I did it on that particular day? Was that in the record?
Yes, Your Honor. I think I'd like to point you to, I believe it's record number 506. I'm sorry, 507 is I think the testimony you're looking for. The question is, on March 16th, 2007, which is the date of the accident, you would have done a final walkthrough to make sure the site was safe?
Counsel, you would have done, not you did.
In that circumstance, I understand.
What is his answer?
The answer, at the end of the day, before Savetta left, we would do a final walkthrough to make
See,
sure.
this is the problem. We would do, not on that day. I remember I did, which is what is required under our case law. Otherwise, it's all speculation about whether, which is what I believe my colleague is alluding to, is speculation about what your normal practice is. Our case law requires a more definitive, concrete answer about this is what I did on that day.
Yes, Your Honor, and two things to respond to that. First, taking those 3 points of his testimony, taking them and reviewing them all at the same time, that he was there on the date of the accident, that he did inspections every day that he was there. Taking that all together, that testimony does support.
Counsel, triangulation doesn't respond to the need for specificity here. Mr. Hires never said that he actually conducted an inspection on the date of the accident. He never testified that he saw the plywood or didn't see the plywood when he left the work for that day. We don't know what he did.
Your Honor, it's true he never.
And there's no inspection log, as you know.
Correct, but for the inspection log, there's no requirement for that, but.
No, but it would have been helpful.
Yes, but, and I agree with Your Honor that he never said in one sentence, on this date, I did an inspection of this.
He didn't say it in 2 sentences.
Your Honor.
He never said it. He implies it. I usually do this, and therefore you should assume I did it on that day. That is not enough under our case law. If we don't have an affirmative statement alleging that on this day, prior to this accident, I did a walkthrough and there were no pieces of plywood loose on the ground, it's not enough.
Your Honor, respectively, the 3 points of testimony that he states, I believe does establish that, because he says, I was there on this date.
Counsel, may I ask you, did he put in an affidavit in support of summary judgment?
From the witness?
Yeah, from the witness.
We just use his deposition testimony.
Right, and he could, right, so his deposition testimony doesn't say it. So he could have easily put in an affidavit, because you know what our requirement is to dismiss as a matter of law, could have easily said, just like I said, and here's even clearer, yes, on that day. Did he put in anything like that?
Well, Your Honor, no, but I believe it's clear from
Well,
his.
clear, you have 5 people here who are
Yes, Your
telling
Honor,
you something
I'm-
else.
I'm
So I'm
trying-
saying to you, why not just put in the affidavit that says it straight out?
I didn't handle the case at the lower
Okay,
court, I don't
thank
know. But, I mean, if, taking these 3 points of testimony in conjunction with each other.
Counsel, you've made that argument already 3 times. Is there anything else you
Yes.
want to say?
Yes, Your Honor. I think the important case to look at in this matter is Rosario, in which the testimony is nearly identical to the testimony Mr. Hires gave in this case. The testimony in Rosario was that defendant superintendent testified 3 things. He inspected the area daily. Second thing, he mopped 3 times a week. Third thing, he swept the stairs every day.
Except that therein lies the difference, that in that case, the superintendent specifically testified as to his cleaning activities prior to the accident, unlike here.
Your Honor,
I'm supposed to assume it based on practice.
Your Honor,
That's the difference.
in Rosario, Your Honor, I don't see a difference. In Rosario, he testified, I inspected every day. In this case, he inspected twice a day.
No, he also testified about what he did that day. And therein lies the difference.
Your Honor,
Counsel, you have a time on rebuttal.
thank you.
Okay?
Good afternoon, Your Honors. Todd McCauley on behalf of the defendant respondent, Savetta.
Well, counsel, let me
Sure.
Let me just ask this question, just I guess in reference to the cleaning issues. Can you speak on that? He spoke about the 16th. The question was posited to him March 16th, and his answer was about March 16th. Does that matter at all? If it's so general, we would have.
I can tell you that I've had the pleasure of being on this file for over 15 years, and I've gotten old and gray managing the file. The witnesses in this case testified that they didn't have any personal knowledge of doing those cleaning practices. They testified as to a matter of custom and practice and routine, if you will. The case had actually been stayed for a very long time before these depositions even went forward, about 10 years in fact. So none of the witnesses had any recall whatsoever about what happened on the data loss.
And may I ask you, were there any documents that would back up their general practice?
There were documents that they were lost, and that's indicated in the lower court decision.
Okay, so
And so
maybe the jury
my
believes
issue's a
it,
very
or maybe
narrow
they
one.
don't,
My
right?
issue's a narrow one. It's the contractual indemnification claim, and I think the lower court got it right. Their issue's a fact. Thank you.
Okay, thank you. He kept to his word. He's under 2. You have 2 minutes.
Thank you, Your Honors. I'd really like to reiterate the importance of the Rosario case here and the testimony elicited there, and it's nearly identical. In Rosario, it testified that he inspected the area daily. That's what our witness said in this case, too. In fact, he gave a time frame which is more detailed than the testimony that was given in Rosario, which this court found to be sufficient. Your Honors, I really invite any distinguishing factors between that testimony in Rosario and the testimony here.
I've said to you, and you refuse to accept it, but in Rosario, the superintendent specifically stated and testified as to his cleaning prior to the accident on that day.
Your Honor, the testimony in Rosario is that he cleaned every day, and that's what we have here.
Counsel, yes, he may, the 2 are not mutually exclusive. He could have testified, this is my usual practice of how I clean each day, and on this day, that's what I did.
That's what
That's what's missing here.
Mr. Hires.
Your client, your witness did not say, and that's exactly what I did on this day. I don't even know what time the workers who were on site that day left, since the accident happened 3 hours after the normal time that this sub leaves the site.
Your Honors, in the record, pages 500 to 501, if I may read from that, because that's the testimony I think is critical here. Because he does state that on page 500.
Counsel, I don't know that you can get around our basic problem with with your argument, which is that the language is equivocal, would have as opposed to did, and you can't undo that.
Well, the would have language was from the questioning attorney. He specifically stated, I inspected this place every day. There's nothing unequivocal about that.
All right, thank you.
Thank you.
People versus Terrence Graham. You may proceed.
Thank you, Your Honor. Your Honor, and may it please the Court, Sally Kage from White & Case in association with the Center for Appellate Litigation, appearing on behalf of Mr. Graham. Mr. Graham was deprived of his constitutional rights under the Confrontation Clause when he was denied the opportunity to cross-examine multiple witnesses regarding their immigration status.
Why is that important?
Your Honor, Mr. Graham intended to cross-examine them to show that there was an issue of general credibility, but also to show that there was a motive to fabricate based on their immigration status.
There were 6 eyewitnesses, all of which said that Mr. Graham had a weapon. Why isn't that evidence overwhelming and would outweigh any other issue here?
Well, Your Honor, it's true that there were 6 witnesses. However, there was no other evidence aside from witness testimony that tied Mr. Graham to the gun.
It is rare that a prosecutor has 6 eyewitnesses. 6!
Your Honor, that's true, but
And there was no damage done with respect to the actual happening of the event in terms of the examination of those witnesses. So on the substance of what happened, there really was no daylight between the witnesses. This was a strong case.
Your Honor, Mr. Graham sought to question the witnesses on their immigration status and noted in order to provide a motive for them to fabricate, which goes to the very heart of his defense.
Poison the jury is what was intended there because it has absolutely no relevance.
Well, Your Honor,
And it goes contra public policy, because what we don't want to do is prevent victims of crimes, some of whom are undocumented persons, from coming forward and getting their justice from the system, right? So there's a very valid public policy reason behind the exclusion of such testimony unless you are able to raise an actual substantive basis.
Your Honor, there is a policy reason there, of course. However, Mr. Graham sought to question the witnesses to show that there was a motive to fabricate.
So let me
He alleges that, pardon me, Your Honor.
So how do you get around People v. Garcia, where we found that the court providently exercised its discretion in limiting the scope of cross-examination regarding immigration status? How do you get around the fact that People v. Anderson says that the court has wide latitude to place limits, reasonable limits, on the scope of cross-examination? As my colleague just indicated, the immigration status of the witnesses really was immaterial.
Well, Your Honor, the immigration status of the witnesses was not immaterial to a motive to fabricate. The additional consequence of being convicted of a gun possession charge for an undocumented citizen would most likely lead to deportation.
What evidence was proffered by the defendant here? What iota of evidence was proffered by the defendant here to suggest that any of these witnesses were the actual possessor of the gun? Because the factual backdrop to this case is these were all workers on a construction site. And the defendant here, who was not authorized to operate a piece of mobile equipment at the construction site, was told by one of these victims, you're not supposed to operate that. and he then leaves the site and gets a gun and comes back.
Your Honor,
And 6 people say so and have to disarm him, right? That's the allegations here.
Your Honor, Mr. Graham contends that it was not himself, but in fact one of his coworkers who had the gun in the melee that ensued, and that as a result of possessing the gun, there would be the additional consequence of deportation that was at risk for them. And therefore, those witnesses, as well as the other witnesses who were their family members, longtime coworkers.
So I
and
guess
friends.
I'm not following your argument. Is it to say that in any instance where someone who is undocumented might be harmed or reports a crime to the police, that there would be a basis for them to fabricate the story based upon their status? I mean, how is that relevant to this particular incident, whereas Justice Masnet Daniels just laid out the facts, and we have 6 eyewitnesses who all said the same thing: he had this gun.
Your Honor, we're in a situation where an undocumented immigrant was simply a victim of a crime. That would be one issue. Here, Mr. Graham is alleging that one of the witnesses was the actual possessor of the gun. So that's slightly different than any other scenario. And here there were.
But the only evidence to support that is his saying so.
Well,
Because while admittedly at least 4 of the other individuals were family members, there's one person who's not related to these victims at all. He's just a coworker.
yes, Your Honor.
And he supported everything they said.
Your Honor, the worker in question worked at the company for a year, had close ties or worked closely with the witnesses as opposed to the defendant.
As did the defendant.
And he continued to work with, the defendant worked at the company for a very short amount of time relative to the other workers and did not interact with the witness, Mr. Burns, very much.
Okay, you'll have time on rebuttal.
Thank you, Your Honor.
You may proceed.
Thank you, Your Honor. Good afternoon. May it please the court, Stephen Kress on behalf of the people.
Counsel, in the proceedings below, the prosecutor did make a statement that a couple of the witnesses were undocumented, and that's kind of where the defendant starts hanging his hat on this right to confrontation to ask about their immigration status. Is that a sufficient good faith basis for us to put aside public policy on this issue?
I'm sorry, is the fact that some of the witnesses were undocumented immigrants, is that sufficient to?
Well, the prosecutor was the one who highlighted it and brought it up to the court, and is that a good enough basis?
The mere fact that we disclosed to the court that some of our witnesses are undocumented? No, I don't think that that's a justification for then allowing cross-examination on the issue. I think that was raised in order to, if the court did allow cross-examination, allow that witness to have his own representation and protect his own rights. I think that's one of the reasons why this was raised in the first place. But I don't think that opens the door to cross-examination wholesale on this issue. Two other points that I want to make on this issue. The first is that we don't actually know how many of the witnesses were in fact undocumented. We know Alex Lopez was.
I understand one person was documented.
Yes, at least.
One out of the 6.
And we know for sure that at least 1 out of the 6 was. We know for sure at least 1 out of the 6 was not. In between, we don't really know. So, you can't say that, for all we know, 3 out of the 6 would have been completely unaffected by this issue. Secondly, even if they were allowed to be cross-examined on this, that's not a reason that the jury would have discounted their testimony entirely, particularly when it's so mutually corroborative among the 6 witnesses. As Your Honors have pointed out, this is not relevant, or at the very best, it is minimally probative of anything. And so I think it's the idea that the jury would have rejected the testimony of these witnesses simply because they were undocumented and this was explored on cross-examination. I just don't think that's realistic.
And that wasn't the only evidence. The evidence of the actual workers who interacted with the defendant upon the display of the gun are not the only witnesses who testified, correct?
That is correct, Your Honor.
In fact, there was a manager, a project manager, Neftali Cornett, who was approached by the defendant and who shared some of the defendant's comments prior to leaving the site because of the argument he had had over the use of the mobile equipment, correct?
That is correct, Your Honor.
And during that discourse, it was revealed that the defendant uttered what one can easily perceive as a threat to come back and quote, unquote, "I'm gonna light this place up."
Yes, Your Honor, that is all correct. Unless the court has any other questions on that particular issue, I do briefly want to talk about the predicate sentencing issue.
Okay.
And really, the bottom line on that is I think the defendant has already received the remedy that he's entitled to under the law, not just with respect to the...
What about the fact that there's been no opportunity, though, for him to, for determination to be made on the prejudice issue under Cat 2?
Well, so, Your Honor, even if he had established prejudice, the remedy that he's entitled to would be withdrawal of his plea. He was given that opportunity in 2010. He declined it.
Wasn't that unrealistic based on the particular circumstances where he was just about to be released from prison?
No, it made perfect sense for him to not withdraw his plea at that point. But I think my point is he was given the only remedy that he was entitled to for this violation. He rejected it. To the extent that there's still a problem, it's because he was given a chance to cure it, and he declined to do that.
Was he really given a chance under these particular circumstances is the question. Where it would have meant that he wouldn't be released at the end of his prison term.
No, I think he was. Because, yes, circumstances change. Time goes on between the time that you plead guilty and the time that this could be raised on appeal or at a resentencing. But I think the fact remains that that is the relief that you are entitled to. And so I think that's what the Court of Appeals has said. So I think that if that's all that you can get, and the fact, I think they understood that this could be the circumstance where you serve a significant portion of your sentence, and therefore it wouldn't make sense to withdraw your plea at the time. But
So you know that under CATU, we have advised that the pronunciation of, or the explanation that there will be a PRS that as part of the sentence is significant because a violation of the PRS will result in reincarceration. Under those circumstances, what problems do you have with a remand?
no, look, the court could remand. And I think the court below made it pretty clear that he didn't think the defendant would be able to establish prejudice in this case.
Make an actual finding, right?
He
Could have, but he didn't.
he did not. He did not. He could have, but he did not. No, I don't think this court could not remand, but I don't think it's necessary.
Thank you. Okay, counsel, you have 2 minutes.
Your Honor. First, I'd like to address the sentencing argument, and would like to say that respondent failed to address Mr. Graham's argument about the prejudice in briefing, and that the issue is that under the statute for convicting a persistent violent felony offender, it is unlawful to use an unconstitutionally acquired sentence for that. And so for that issue, we ask the court to remand this matter for proper consideration of Mr. Graham's predicate challenge.
And what about the fact that he didn't make that request at the 2010 resentencing?
I'm sorry, Your Honor.
What about the fact that he didn't make that request in 2010 to vacate his sentence?
Well, Your Honor, the 2010 sentencing only dealt with the procedural error. It could not do away with the constitutional error in the
But didn't he have an
2002 plea.
obligation to raise that issue then?
Your Honor, that,
I mean, if we send it back, it's not to find that it was unconstitutional, right? It's just for a prejudice finding.
at the time of the 2002 plea, that plea was not made voluntarily because he was not informed about the consequences of it. That the correction in the 2010 resentencing is only a correction of the procedural error. In the case that respondent cites, Sparber, the court does not reach the constitutional error issue there and only addresses the procedural issue in sentencing.
Thank you so much. And on behalf of this court, I want to thank you and your firm for taking on this case and assisting the Appellate Defender's Office.
Thank you, Your Honor.
Thank you so much for your pro bono service. Thank you both. All right. Reed versus 645 LLC. I thought that was submitted. Oh, sorry, that one's submitted. Aha. Singer versus Bill de Blasio. I'm recused. And Justice Elizabeth Gonzalez is recused from this case. Should we have a tie, we will follow the court's rules and vouch in another judge to break the tie.
Good afternoon, Your Honors. May it please the court, Diana Lawless on behalf of the city defendants, which are the Department of Buildings and the former Mayor Bill de Blasio. Supreme Court should have dismissed the tortious interference with prospective business relations claims. We think, as laid out in our brief, there's many grounds. We think that the clearest one that applies actually to all the defendants and was not addressed by Supreme Court and I think barely answered by our adversary in his papers is that the plaintiffs cannot recover because all their allegations are about the city's acts directed at them when the claim only allows to recover for conduct directed at a third party for which a plaintiff has or seeks to have a relationship. Here, there's nothing other than what courts have derided as a vague reference to an intentional course of conduct designed to induce business partners to change their minds. There's nothing here about what the city did, what the Department of Buildings did that was directed at either the Adelphi or at Madison, the lender. As to the city, another ground that there can be a reversal on is that basically because any challenge to the decision to deny a permit related to the lease executed with Adelphi fails because it should have been brought in an Article 78 proceeding. Most of the complaints spend attacking the time frame of the review of the lease and the rationale behind it. It's proper for Article 78 review because the claim is that the denial was in violation of law, because it was poorly mandatory, and it was denied only because of improper influence of the other defendants. Article 78 is the sole vehicle to challenge the performance of administrative agencies of their legislatively imposed duties, of which one is issuance of the permit. The court here was wrong to find that the alleged acts were with an improper purpose that took it out of Article 78, when whether a decision is made for an improper purpose is the heart of Article 78 review. As you know, we have other arguments about how even separately from Article 78 review with respect to the city, this was separately a discretionary determination, discretionary governmental function for which damages are unavailable in tort, which is a tort claim. And then as to the claim itself, we also argue that there are not sufficient factual allegations about prospective business relationships with unnamed potential business partners who are also listed or not listed in most cases with Madison the lender. And then also that...
Well, counsel, let me just ask you this question. In terms of statements that were made publicly in the press, would those be any basis to find that there could have been some interference, or is that would just be conclusory and speculative to assume that?
I think it is conclusory and speculative for different reasons with respect to for different reasons. These statements were made by the mayor after the permit denial, like the date, it's pleaded the day after the permit denial, so that takes everything with respect to Adelphi out. I think it is speculative and conclusory because it's just said that these statements were made, and anything about unnamed business partners is conclusory. We don't know about anything that happened. And anything with respect to Madison, the allegations are basically that at some point later on after these statements, because there was a perception that the plaintiffs were bad business partners, that nobody wanted to enter contracts with them, and that's why Madison foreclosed. It was a year later. So I think it's just speculative and conclusory. The cases require specific acts, specific factual allegations, and we don't have those here. Thank you.
Thank you, Your Honor. I'm Charles Dorkey from Denton's for East Village Community Coalition and Aaron Sosnick. We respectfully submit, Your Honor, that the trial court below, the IS court, erred in not dismissing the claims against us under the Noor-Pennington Doctrine, which provides constitutional First Amendment protection for lobbying city government and lobbying officials. Court concluded without much analysis that that our actions fell within the sham exception. But I respectfully submit, Your Honor, the sham exception has two parts to it, one objective, one subjective. If you meet the objective, you don't go to the subjective.
How does that tie in with the tortious conduct allegation, generally with the interference with prospective business relations? Because it seems like if you have one, then you have the other. If you don't have one, you don't have the other. Because the tortious conduct that would be required under the interference is the same as the tortious conduct sham in the Noor-Pennington.
I think you're right, Your Honor. They're very similar in the type of the issues that involve it, because in both of them.
Why does the conduct here not rise, since it addresses both aspects of the argument to wrongful conduct?
Well, okay, so first, that's a subjective test under Noor-Pennington. The objective test is basically, if you're successful, it can't be a sham. The one thing we were successful about is since 2008, every court and administrative agency other than Justice Bork has agreed that the dorm rule applies. And this is what our clients, the EVCC and Aaron Sosnick, asserted. Consistently, the dorm rule applies. The allegations against them of doing things outside of lobbying to make it illegal, going to Justice Pittsburgh's point, is conclusory and speculative. It's not, it's all conclusory and speculative. So
then, counsel, how do you explain the statement by the DOB, whoever it was, the city person who said, this is going to happen, and then a flurry of activity from your clients, and then it doesn't happen?
Actually, it wasn't a flurry. I mean, I know it's alleged there was activity. I think it's unfair to say it's a flurry.
Okay.
Two, it also took quite a period of time.
I don't think from the petitioner's perspective it matters much whether it was a flurry or one-time instance. This is the third time they've had potential contracts to build out this property, and they continue to get blocked.
Well, Your Honor,
So they get sold the property, and then somebody has decided, you know what, we sold it to the wrong guy.
well,
And it seems like every single time this man tries to put a deal together to develop this property, he gets blocked.
Your Honor, I understand the sympathy you have for someone in that situation.
It's not about sympathy, it's about equity.
Okay. The point about it not being equity, Your Honor, the point of it not, what's unfair to the community, because from the beginning, he did something that was not allowed.
Says who?
Well,
If Mr. Sosnick is the individual who has financed this coalition, how do I know whether this is actually the sentiment of the people of the East Village? How do I know that?
Well, there's other evidence that there are other people in the East Village. For instance, in the federal complaint before this, EVCC was not sued. Mr. Berman and the Greenwich Village Preservation Society was sued. The same allegations that are against EVCC were against them. That is in the record in terms of.
Let me ask you this: what about the statement? I think was it by your client or that to Madison, I could buy out this loan real quick? Who did that?
Well, what an email said is, if it's not going to work, We have money to pay it out so that Mr.
That was
Singer-
your client, right?
Yes, Your
So
Honor.
your client says, don't build this because of the dorm room, and by the way, lender, I'll buy that property from you,
Okay,
right?
well,
Are those the two facts?
Right, now that I have succeeded in throwing a monkey wrench in this again,
Your Honor.
oh, by the way, we're willing to do this. We got the money.
Your Honor.
And then when you got the help of the mayor making comments publicly.
Your Honor, I would respectfully submit that the comments of the mayor are irrelevant under Nora Pennington. But
Or what?
Irrelevant under Nora Pennington. It is out, even though there are less than pure motives in the one.
Counsel, we know that the statements of public officials has an impact on society. We know that. Every time, I mean, we're going through a situation where we have our financial condition in this nation, and we sit there waiting for each new report of the head of the Federal Reserve, right? Just as an example. And what he says has an impact the next day on the stock market. So don't tell me that the comments of a mayor don't have impact on public confidence of a bank who's willing to lend $44 million for this project. Let's just not play pretend, okay?
All right, Your Honor, I don't mean to annoy you, but it's under analysis under the constitutional rules of Nora Pennington. The fact there are other motives besides petitioning government is irrelevant. It's that activity is still protected.
Okay.
And I'd say.
Thank you. You'll have time on rebuttal.
Okay, thank you, Your Honor.
Next one up. You may proceed, sir.
Thank you, Your Honor. It's Thomas Leghorn from London Fisher on behalf of the appellant George Arts Communications. And we are the lobbying firm that was hired and in this matter briefly. And
By Mr. Sosnick, correct?
by East Village Community. Well,
By Mr. Sosnick.
financed to a great
Right.
degree by them. But that's irrelevant, as Mr., and I understand Your Honor's comments about comments of public officials have impact. But the matter is, the public officials are free to make those statements, and they are afforded great immunity.
There was a letter that was sent prior to those public statements that said, hey, we have these private investors. And then all of a sudden in the press, the city official is saying, we might sell it to a private investor. Is there any relation there, anything that might impact our decision here?
No, Your Honor, and especially in connection with, I'm dealing with my client here, the lobbying firm, who's not involved in sending those letters or whatever. And the Nora Pennington doctrine.
May I just ask you for a moment? You were not hired, and there's no evidence whatsoever that Mr. Sosnick himself hired you?
Right, the engagement letters that are part of the record are from the East Village Community Council, and it is not from Aaron Sosnick.
So there's no,
No.
in your position is, there's no indication that he was hiring us personally?
Correct.
Okay.
Correct, Your Honor. There were a lot of people that clearly had input, and this was a major issue among the community, but our client was the EVCC, and that's what the documentation is. But, as Mr. Dorkey was saying, this is, a paramount right of, that belongs to lobbying firms and others, and it embodies the First Amendment right to petition government, that it is a very, very, very strong protection that's afforded, because it could,
All right, so let's go to the sham exception. Why shouldn't we find that the evidence, at least at this stage, is sufficient to overcome the sham and and the evidence I think we've gone through already, which is there was indications that it was going to be approved, and then there became lobbying, and then it wasn't approved, and then Mr. Sosnick's group said, we will, to the petitioner's lender, oh, by the way, we can buy out this loan, which means we can take over the property.
Correct.
Why shouldn't we find that that's sufficient to overcome this, to at least state a sham exception to the North Pennington document?
Understand, Your Honor, and the North Pennington comes into play exactly at this stage.
I know, you know, I know, we both know, so why, let me ask you again, why isn't that
Exactly.
enough, at least at this point?
Yeah, but there isn't enough in the pleading to establish that. First of all, the pleading is drafted in a manner to throw everyone together, to use these derogatory terms that the conspirators, whatever, lumped together without any differentiation. And so it makes it hard for the court below, to parse out who is alleged to have done what and what is actually being alleged. But beyond that, you know, so the sham exception, the cases are replete that, you know, and even, you know, the Conquest Nursing Home case from this court was that you don't get any further with looking at the sham exception when you're successful. And all my client was doing was asking the city to take another look at this. And they succeeded in having them do that. Whether it was right, wrong, different, that's Article 78, whatever. It's not a claim against our client.
And so your position, obviously, is I'm allowed to do whatever I want. It's a dog-eat-dog world out there, right? I'm entitled to lobby my people, lobby the legislature to go in a way that will help my business and not somebody else's.
Exactly, but with very limited exception.
Right.
It doesn't come close to it. The cases have said it has to be almost criminal. It can't be just alleging that it was unethical or you hurt me.
Thank you.
Thank you.
Good afternoon, Your Honors. James Vinacore from Goldberg Segalla on behalf of Mr. Wolf. I'm going to speak primarily about the tortious interference with prospective business relations as it applies to Mr. Wolf, and specifically towards the element that was not sufficiently alleged within the complaint, that Mr. Wolf acted solely out of malice or used improper or illegal means when directing his actions towards the parties. To be clear, Mr. Wolf's actions as alleged in the complaint are of sending an email to a city planning official in 2017 and then to Madison Realty in 2019. Mr. Wolf is a broker who earns his commissions entirely from brokering real estate deals. And so in both of these cases, his goal was solely a self-interested financial one. In Carvel versus Noonan, the Court of Appeals state that these wrongful means require heightened culpability. They use the phrase physical violence, fraud, or misrepresentation. There are no allegations that those emails contained fraud, that they included misrepresentations, or other economic pressure. This economic pressure is simply not here. And the court, in fact, said that conduct which is motivated by economic self-interest cannot be considered by itself as solely malicious. In fact, plaintiff himself concedes this in his complaint when he stated that Mr. Wolf acted out of a pecuniary interest and to satisfy other interests in this case. So for those reasons, the plaintiff's allegations have failed to satisfy the pleading standard for tortious interference with prospective business relations. Thank you.
Thank you.
May it please the court. I'm Matthew Press for the respondents. Justice Barak was absolutely correct in holding that the complaint sufficiently alleged that Mr. Sosnick and his agents, including EVCC, which the complaint alleges was a front organization funded entirely by Mr. Sosnick and designed to create a false appearance that it served a public purpose, intentionally interfered with what was a purely ministerial permit process under dorm rule, just to block the development of the property.
Of a permit, purely ministerial.
Oh, Your Honor, I'm so glad you asked. The case law cited in our brief indicates that obviously there's some types of permits, a construction permit where you have to look at something more. But the dorm rule was a type of permit process that was very, very specific, and it's really required just two things. that the party seeking the permit was an accredited higher educational institution, and that the term of a lease would be 10 years.
Counsel.
That's it.
This issue was in some part before the Southern District, wherein they said that it wasn't just a ministerial performance of a duty. How do we reconcile what you're arguing here today with that?
Well, Your Honor, the trial court felt that the issue was a different issue. It was I believe it was a different lease. It was a different situation. All I can say, Your Honor, is that the law is clear. There's simply, I'll read the law on this, was that a discretionary act involves the exercise of judgment, is something that can produce different acceptable results. Here, a ministerial act, on the other hand, involves direct adherence to a governing rule or standard with a compulsory result. And that's the case Tango versus Tulovich cited in my brief.
So my question to you, and it was raised by the city's council, was if you thought that their decision was wrong, why did you not move through Article 78 to contest that decision?
Your Honor, I understand that there was a separate Article 78 proceeding relating to the permit. This is an action that
So you didn't follow through in that Article 78 proceeding. You have to exhaust your administrative remedies and then bring an Article 78 proceeding. And the petitioner here never went through those steps and just abandoned the Article 78 and said, what a contract action.
Your Honor,
Because it seems to me that your entire case hinges on the fact that the city wrongfully denied you that permit.
Your Honor,
And until we establish that, everything else is just extra that I can't act on until we establish that the city wrongfully denied you a permit that you were legally entitled to.
So, Your Honor, if I may, one thing that's very important. I heard my colleagues when they started out talking about what is and what is not in the pleading. And since Justice Barak denied the motion, there's been substantial discovery. And for one thing, we've established that, and I understand it's not before the court, but I think it's important as you issue a decision on this appeal, that there has been evidence established of direct contacts between Sosnick and EVCC and his representatives.
Counsel, why doesn't that go back to the article? We can't consider it, but why doesn't that go back to the fundamental Article 78 question?
Well, the answer to that
your
question,
remedy, if the permit was wrongfully denied for whatever reason, or wrongfully delayed for whatever reason, was to bring in Article 78, so a court would have the opportunity to make a determination one way or another whether the wrongful denial or delay of that permit was appropriate or inappropriate.
Your Honor, the answer to this is not an action, and it's very clear, this is not an action to challenge the permit, to seek a new permit. This is an action to obtain monetary damages.
But all the damages that flow from your claim, every single item of damages flows from the denial of the permit. If the permit was issued, then you would have gotten, your client would have gotten everything they wanted, and everything they didn't get was because the permit was denied. So how can, as my colleague stated, how can these ancillary issues be decided without a determination of that fundamental issue?
So, Your Honor, what was necessary in order to achieve the conspiracy of the defendants was not to get the permit denied, but to get the permit delayed until Adelphi had no choice but to cancel the lease.
But
because
isn't
it
that
was
also something that could be dealt with in an Article 78 proceeding?
Your Honor, once again, that the law that we cited in our brief indicates that you could have an Article 78 proceeding, but this is a different claim. This is a claim for monetary damages against third parties for abusing.
How can we make that determination in a non-Article 78 proceeding?
Right.
Because to determine any of these claims, we would have to make that determination about whether the permit was wrongfully delayed, denied, and how do we as a court even have authority to do that without having an Article 78 proceeding?
So, Your Honor, at most that might relate to the city defendants. That has no application to the non-city defendants.
But how can you decide whether anyone else did anything wrongful without deciding whether the city did something wrongful in the first instance? If the city was completely justified in all its actions with respect to the permit, all the other claims would automatically topple.
Your Honor, I don't believe that the court can't make a determination about whether the city was correct or incorrect on blocking the issuance of a permit. I think it's a different issue. An Article 78 proceeding would be seeking not monetary damages, but seeking a permit itself. It's a different animal. The cases that we've cited indicate also...
Counsel, look, I don't necessarily disagree with the last thing that you said. The problem that you have is all your other claims start with the denial of this permit. Because if the permit had been granted, you would have had no default on the Madison loan. You would have been able to go forward on the contract with Adelphi. We wouldn't be here. So I'm sorry, I don't accept that we can just ignore or bypass that issue and deal with the others. That is a central
Your Honor,
issue here.
I believe that is a defense only for the city defendants, and it is only something that would impact an attempt to obtain a permit and seek declaratory injunctive relief that there should be a permit.
One of the main elements under the interference with prospective business relations is whether wrongful means were used. And how can you make that determination separate and apart from whether it was right or wrong to issue the permit?
So, Your Honor, I don't believe there's any reason why the court can't decide whether it was rightful or wrongful to issue a permit.
Again, counsel, you can't do that if counsel, but you just literally, we are not permitted to do that outside of an Article 78. Even if you say it's ministerial, it is an Article 78 under you didn't do your ministerial act, or if it's a discretionary, then it's an Article 78 that you abused it was arbitrary or capricious. We have to agree at least on that.
So, Your Honor, I believe that if the city defendants were not in this case, we wouldn't even be talking about this. The Sosnick...
But they are.
And
they are at the heart of the issue.
But, Your Honor...
Counsel, we have your briefs.
Thank you very much.
Because we're going in circles.
Thank you, Your Honor.
We're not going to agree. Everyone has 1 minute on rebuttal.
Hey, Your Honors, I think you got to the heart of it after the last discussion with my adversary with respect to the city as to the Article 78. I think it begins and ends with us there. I know Justice Kern asked, or Justice Carpula asked, is there anything you could have done about the delay? I think the delay is not really the crux of the complaint. I think it is the denial. But yes, we put in our...
But the delay was an issue because they had a contract that this permit had to be issued by a date certain, and the city's dragging their feet prevented them from being able to make good on their contract. So while not directly an issue, it is an issue.
Your Honor, I understand your concerns, and I understand, but it also, there never was a breach. There was an option to exit the contract. It didn't have to be done by a date certain. The parties could have continued to negotiate. They had an option to exit if there wasn't, at least by that date. And I will say, Your Honor, I mean, just coming from the perspective...
Counsel, he bought this land over 20 years ago, right? When is this man going to be allowed to build on this property he bought?
Well, Your Honor, I don't know, but from the city's perspective is that you have to comply with the dorm rule. Many courts, including the Court of Appeals, have held that this particular petitioner hasn't. And honestly, that's also not the only use of his property. He can make other use of his property. It doesn't have to be a dorm.
Well, I agree with you. He hasn't found the right partner. Next.
I'll address some points very quickly, Your Honor. We contend this is not an as-of-right decision to issue the permit. It is not ministerial in any way. It requires discretion, and we've cited authority for that. You asked about, there was an email that said the city was going to grant it, and then it didn't grant it. I would suggest, Your Honors, that that's no different than you're getting a bench memo before something and then changing your mind after oral argument.
Except that memo doesn't go out to our client, to the litigants. So it's not the same thing.
Well, it wouldn't be the same thing were it not for FOIL, but but you're
no, that is not something you could get through FOIL.
No, I understand. I know. Sorry, I don't mean to say you're. So, our opposition to all this has consistently been to ensure that the project complied with the dorm rule. The dorm rule, and that's the subject of our amicus brief in 2008, where we took that view. It's been our view consistently about the dorm rule. And
thank you.
Yes, I think that means I'm done.
The red light is on, unfortunately. Next.
With so many attorneys arguing before you, I think we've covered a lot of the issues, and our position is fully set forth within our briefs.
Yes.
So unless your honors have any additional questions for me and my client, George Arts, I'll stand on our briefs.
Thank you.
Thank you.
Have a good afternoon. And you have 1 minute.
Your Honor, I'm going to echo Mr. Leghorn's statement. Unless the court has any questions for me, I'm going to rest on the record before the court.
Thank you so much, and you
Thank you,
have a
Your
good afternoon. All right, thank you so much. Have a good day all. Gilder versus Stern. And let's wait for Judge Gonzalez to return. And you have 6 minutes, sir.
Good afternoon, Your Honors. My name is Joshua Liston. I represent the appellants here, who are the defendants below, Michael Stern and David Drossage. Your Honors, appellants submit that the court below got it right the first time. What started as a fairly simple dispute before the court below, I think for
How did the court get it right when it didn't address the issues raised in the reply?
It did, Your Honor, and if I may, in the original decision, which was issued in September 2022, the court is actually very clear about what it considered before it issued its decision, finding that summary judgment should be denied. And this is at, the opinion begins at record 221. In the first instance, you see, just as a mechanical note, all of the documents that the judge considered. I understand.
Yeah, so that's like a press of the button, right? So you go into NICEF, any document that's associated with that motion is listed on that form. But then on re-argument, the court says, oops, didn't actually deal with this. And here's what I have to say about this, right?
So, Your Honor, it wouldn't be my duty had I not pointed that first part out. But even in the original decision, right, because we have a basic promissory note, a demand letter.
Well, let's get to the heart of it. How did the court in its original decision address the very specific argument made on reply?
Sure. This is on record page 223, and the judges were counting essentially plaintiff's arguments, defendant's arguments, and then it says, plaintiff's reply affidavit states, defendants raised two defenses, to my action. First, defendants claim that certain payments they made to me in 2013 in the amounts of $909,327 and $507,000 fully paid off the note. That is not correct. These payments were due and made in connection with a separate business transaction. So the judge is quoting, actually, Gilder's argument in reply. Nevertheless, the judge concludes, there remains questions of fact regarding the amounts due and whether payment was made on the promissory note.
Counsel, just in response to that, at record page 98, there is an email that indicates what that payment was for, right? It talks about a 2009 transaction, and it references the specific amount, and then we have the document that indicates where the wire transfer was made. Again, why doesn't it end there?
For two reasons. One, that even if this email is, let's say, correct to the person, to the point of view of the person who wrote it at the time, the Karst opinion tells us that that's not enough to win on the summary judgment stage. It's certainly an argument that they could make during—
That is not right. What that case talks about is evidence in chief. So Stern puts in an affidavit that says, no, that's that payment that was made, this $1.4 million payment is made for this, we paid it off.
Right.
And then on reply, the plaintiff says, I have a statement against interest, defendant's statement, in which he says this. that and shows that it wasn't for that loan. That's a completely different situation, perfectly permissible. So assume that it's permissible, right? And we have the statement of your defendant admitting not the payment that Stern says it was. Why doesn't it end there?
Sure, because Jurassic is wrong in his email.
So then on reply, does he put in an affidavit that says, I was wrong in my email?
There was no reply. That
Right.
this
No,
first came.
on re-argument or renewal and whatever else that you missed, right? And then you said, please vacate my default. And if you do vacate my default, here's Jurassic's affidavit?
So I do have to correct. I was not counsel below.
I just want to know,
I understand.
right? Isn't that the simple way to do it? I lied, I didn't tell the truth. On your motion to vacate, did Jurassic put in an affidavit that said that email was wrong? I didn't do it.
No, he did not put an affidavit.
So that's an unrefuted document, statement against interest. Do we agree?
I do not agree, and the reason I don't agree is because the motion to vacate, what is clear is that the court did not consider the Stern affidavit at all.
But, okay, so the Stern affidavit says one thing,
Yes.
but we have this email from Jurassic that says, this is 2009, we're talking about this, you'll get your money, it's 1 million point four. I mean, why can't the court just consider it and have it end there?
I honestly, I don't believe you can for summary judgment.
Where is the merit in your argument that can rebut that particular email?
The Stern affidavit rebuts the notion that the amount paid, that there were no amounts paid on the note. Now, again,
But the Stern affidavit doesn't address the email.
it could not, because at the time, the affidavit with the email went in only on reply.
And did anybody address it on the motion to vacate?
No one addressed on the
No,
motion.
and there's the perfect affidavit. Here's the perfect opportunity. Please vacate my failure to contest the motion to re-argue. I have a good reason why, and here's my great defense. Stern put in an affidavit. Jurassic put in an affidavit. No one did that, right?
No one did it, but there's no reason to think he needed to, because that information, well, the reason why is because the information was before the court.
All of us asking you about it.
And I'm going to let you think about that for your reply.
Understood.
On rebuttal. You may proceed.
May it please the court, Michael Lane, Barclay Damon, for the respondent Warren Gilder. Your Honor, you made exactly the right point here. What happened in this case is very, very simple. Mr. Gilder had a simple 3213 motion to try to get back his $400,000 note, and it's turned into an odyssey by what the defendant has done. They come back with a statement in his affidavit that says, we paid everything off as part of the $1.4 million. They give no specificity. They don't do anything other than make that simple claim in the affidavit. And they've had, until through the motion to vacate, a time to give more details. They haven't. That's what, because this is a lie. And the deeper issue here, as far as I see, is that, and I've been practicing a long time, I've never seen an egregious case like this. If you look at the documents, we have the contemporaneous email, which Your Honor pointed out. We have 2 payments, interest payments in 2016. This is all in the record, from defendants to my client. And then we have a smattering of conversations and emails from 2016 to 2021, talking about, I really need to get paid this $400,000, and them saying, we're going to get something for you, my friend. I promise you, we're going to find the money and we're going to do it. When we filed our simple motion, I told my client, this is a simple motion. The problem will be chasing them for the money when we win. Well, I couldn't have been more wrong, obviously. Even if you put aside the fact that this was a lie, a provable lie by the evidence I've just shown you, and you go just as to what that affidavit is, it is the essential self-serving affidavit, which isn't enough. Your Honors, this case provides an opportunity for this court to set forth an opinion I think is really important for the practice of law in the state of New York. I've been doing this for 37 years. I've never had a case like this. Back in mid-'80s, late '80s, when I started, this would have been outrageous. I believe counsel, even in bringing the appeal, has lost his way in connection with his obligation to be an officer of the court. I've been teaching 30 years legal writing at Fordham, and my first class, I tell my students, you are an officer of the court first, before you are an advocate, before you are a counselor. And the fact that we live in the world of alternative facts, we need a decision from this respected second highest bench in the state, in my opinion, and this is the case to make it, that says you can't do this. You cannot do this. I have a quote from Judge Cardozo that I would end with. I don't know if you want it, but it is about officers of the court that my new associate was able to get. It's a 1928 case called People ex rel. Carlin versus Culkin. The site is 248 New York, 465, 470 to 71. Membership in the bar is a privilege burdened with conditions. The appellant, in this case, was received into that ancient fellowship for something more than private gain. He became an officer of the court and, like the court itself, an instrument or agency to advance the ends of justice. Unless you have any other questions, I stand by my briefs.
Thank you so much. Sir, you have 1 minute.
Just very briefly on that last point, I couldn't agree more that those are the obligations of attorneys and others who represent
Counsel,
clients before this court.
I will also tell you that as I went through the record, I became increasingly alarmed. I said, where are these documents leading me? And ultimately, I was asking myself, is there a fraud being perpetrated upon the court? The documents here pose very challenging questions to us.
I am perpetrating no fraud on the court, and neither is my client, Your Honor. The documents that are included in the papers, which again largely went in on reply, right, are handpicked by Gilder, as he absolutely should do, to tell a story.
Again, once again, you get an opportunity on a motion to vacate to put in whatever else you got, and you put in nothing.
If I may have 20 seconds on that?
Nothing.
Just 20 seconds, Your Honor?
Go ahead.
Sure. And I do want to correct what I said before. It certainly isn't everybody's opinion on what should have happened, but from the perspective of prior counsel and what he was looking to do on the motion to vacate, where he needed to show not just reasonable excuse, but also meritorious defense, he had the understanding that based on how the original decision went, that the Stern affidavit would be sufficient. He may have been wrong, but that was what I would believe
Then you look at the
motivated
email
decision.
correspondence, which specifically references the $400,000 loan, and you look at all the back and forth about, yeah, I'm going to pay you, yeah, I'm going to pay you. Oh, I have a big deal going on right now, so I can't do it now. Why don't we go out for dinner? You know, and I'm reading this, and I'm saying, what was going on here? What was going on here? You have two different loans, one at 20% interest, one at 17.5% interest. One gets paid off. It appears like the other one has not been touched. And I don't get it. I don't get what you're trying to do here. I'm not speaking to you as an individual, of course, but I don't understand what your client is trying to do.
I understand. He is trying to get further developments in the trial court so that the full story can be told. I understand where the panel is. I just do want to say, in part because there isn't other correspondence there, you really aren't seeing the full story.
So he should have put it in.
No,
Again, I'm not going to say
I hear you, but I'm addressing the larger issue, which I completely appreciate and wanted to, at least address that. Again, it's again fair in an adversarial relationship for there to be, one-sided presentation. But what you're not seeing in there, for instance, is correspondence.
No.
It's
Fair
on
enough. Fair
you.
enough.
It's on you.
I will not go beyond.
Thank you so much.
Thank you very much.
We will rely on your briefs and the record. Thank you so much. Last but not least, Salitsky versus Miller. You may proceed.
Thank you, Your Honors. Lois Bladicus from Ruskin Moscow Faltachek for the plaintiff appellant. I do see that my adversary is now present, and I had initially requested just 2 minutes.
I'm giving you 5 and 1 and him 5.
Thank you, Your
You
Honor.
may proceed.
Your Honor, we submit here that the Supreme Court erred in dismissing this complaint with prejudice for 4 principal reasons. First, the Supreme Court expressly construed the allegations in the complaint against us. Second, the Supreme Court misconstrued the pleading standard of the claim for undue influence and held this to an impossibly high standard on a motion to dismiss. Third, the court misconstrued the pleading standard under CPLR 3016B, which merely required our client to put the respondent on notice of the claims against her, especially in a case such as here, where the information and the evidence concerning the bad acts are within her knowledge and possession.
You're right there. And just ask you a question about the pleadings, because when it got down to, after the statement of facts and so forth, when it got down to the actual causes of action, the plaintiff's pleadings indicate a neighborly relationship, exchange of pleasantries, and then began to pressure and influence her, which resulted in a decrease in communication towards the plaintiff. But that's just so vague. Why wouldn't more be required at this stage?
Your Honor, we submit that we did plead more than that. In the complaint, we make clear that the respondent was the decedent's neighbor and that they started out as having neighborly interactions, but over time the respondent began to pressure and influence the decedent, Marcialato, to change her estate plan, including not only with respect to the account at issue, valued in excess of $6 million, but also changing her will to nominate the respondent as the executor, issuing that $15,000 check to the respondent when we stated in the complaint that wasn't her normal practice. She wasn't the gifting type. We also specifically pled that the decedent, who was an elderly woman, was not technologically advanced. She didn't own a printer. She would have needed assistance to use a computer, and I would refer the court to the record at page 54, which is the actual beneficiary designation form at issue, which is typed. It contains the respondent's social security number and date of birth, which are redacted for privacy here, but I'll tell you that's what's present. And so it begs the question, how could the decedent, an elderly woman, have known her neighbor's social security number to make her a beneficiary? And so that just goes to our...
Which leads to the inevitable conclusion that form was brought to the decedent, completely filled out by the defendant here.
That's our contention, Your Honor. And the Pludman case from the Court of Appeals makes clear that this is almost a perfect example of that, where the respondent is the party with the knowledge and the information about what transpired between her and the decedent, that we can't be held to an impossibly high pleading standard. I would also point out to the court that I think it's obvious that the court misinterpreted the elements. I'm focusing on the claim of the undue influence here, where the court asked us to, or held that the claim should be dismissed because we failed to explain why the decedent decided to name the respondent as the beneficiary, but that runs completely contrary to the essence of an undue influence claim, which is that the act was involuntary because of the acts of the respondent. And the final point I would make to your honors is that even if you don't agree with anything I just said regarding the pleading standard, it was plain error for the court to dismiss the complaint with prejudice. That's a Court of Appeals, Lanzi versus Brooks, that so this court has a strong policy of deciding cases on their merits, and we should be given, even if you disagree with my arguments on the pleading standard, the opportunity to at least replead and file an amended complaint.
Counsel, the application for injunctive relief was denied below, right?
Yes, Your Honor.
Is there any money left? Does it still exist?
I don't know. I'm not sure whether the respondent has collected the money. We've been unable to obtain that information directly from the bank, but my understanding is that she has, and she's in Japan. My understanding is she's still currently residing there, but I'm not sure at this time where she's residing.
Thank you.
Thank you, Your Honor.
May it please the court, Jordan Whiteberg on behalf of respondent Karen Miller Tatanzio. Your Honor,
Counsel, does the money still exist?
yes, the money still exists. It was transferred over, I can't remember exactly when, sometime between 2 to 3 months ago, I would say. Your Honor, the court below correctly dismissed this complaint with prejudice. The allegations of this complaint are not fact-based.
Well, counsel, we can agree that, yes, fraud and undue influence must be pled with specificity, except in those instances where the peculiar knowledge is within the defendant's frame of knowledge. Why isn't that the standard here?
Well,
why can't we apply
there's
that
a couple of
standard?
very important facts, Your Honor, which is one of the few allegations in the complaint that is not made upon information of belief is that my client, the respondent, moved to Japan in 2018. This form was signed on December 23rd, 2019. My client resided in Japan continuously since then. As appellant's counsel just stated, my client still resides in Japan. Japan's 7,000 miles away, 13 time zones. They claim that the decedent was technologically not adept. So how could there have been undue influence under these circumstances? Another fact that's very important.
Wait. Countervailing facts that the $15,000 gift was revoked, that your client was revoked as executor. There are a number of circumstances which bring some of these transactions to question. Why isn't that enough at this pre-discovery pleading stage, based on all the circumstances, to allow this claim to go forward?
Well, Your Honor, you say that my client was revoked as executor. That took place in 2017. She moved to Japan in 2018. It's kind of natural, in my view, that you change your executor if the person you nominated lives 7,000 miles away. I think it's also important that there was a 24/7 home health aide in the apartment where Marcia Lotta lived. How could there have been undue influence under these circumstances? That's another one of the
Wait,
facts that's
let me go
alleged,
back.
not upon information of belief.
Counsel, when was the $15,000 gift?
It was at the end of 2019.
So she came
That's when
back,
the check was written.
right? That was right. So she wasn't continuously in Japan. She came to the U.S., was with the decedent, and then a $15,000 gift arises and then is revoked. So there is she's obviously having some contact with the person. We just don't know. This is a pre-answer motion to dismiss, right? We have no one has any discovery. Maybe on summary judgment, it comes out that the client visited her every 3 weeks. Who knows? But at this point, you're saying to us that the fact that her one relative who has been her beneficiary is written out of the will, then your client, she gives a gift to in 2019 after she revokes, and then revokes that gift. All those things together don't at least raise a sufficient inference on a pre-answer motion to dismiss?
I don't believe so, Your Honor. I think what we have is a will changing the executor to Karen, and then another will removing Karen. That's not all that significant one way or another.
Changing the beneficiary
And the beneficiary?
of the $6 million in cash, right?
Right, she changed that. Naming someone as a beneficiary doesn't suggest undue influence. I don't see how it could. I mean, it's not like she was married, she didn't have children, she has someone who
But she had a relative who had been the beneficiary for 7, 8 years.
Over 10 years.
Well, she changed the beneficiary. I don't think that implies undue influence. There's no surrounding circumstances.
You would agree, counsel,
There's no evidence of...
You would agree that the elements of undue influence can be established by circumstantial evidence, right, such as what we have here?
Well, of course, anything could be, wait, I don't want to agree to that. It's when you said, such as we have here, but of course it can be established by circumstantial evidence. Where's the opportunity to exert undue influence here when you're...
Let me see, her only living relative doesn't live in the state, and she lives in the same building and can go over and talk to her anytime she wants.
She lived in
That
the same...
sounds like opportunity to me.
She lived in the same building in 2017. She moved out in 2018.
That's okay.
This didn't happen until the end of 2019.
There's so many questions raised here by the circumstances and the documents, too.
Thank you. You may proceed.
Thank you, Your Honors. Just one final point. My adversary raised two questions. How could there possibly be undue influence if she resides in Japan and if there was a 24-hour home health aide? Just to echo what Your Honors just raised, it just raises more questions than it answers. And we also specifically pled in the complaint that Marcia complained to that home health aide that she was being taken advantage of and that she felt tricked by the respondent.
And to her financial advisor, correct?
Correct, who we also...
And if my memory serves me correctly, the $15,000 check that is in question and that the decedent stopped was written in the defendant's handwriting.
That's what we submit, Your Honor. So we respectfully request that the court reverse the lower court order. Thank you.
Thank you.
Good, how are you?
Good.
I was 3 minutes late.